Hi, good morning. My name's Alexis Eykel, and I'm the Landlord Engagement Specialist here at Tacoma Housing Authority. Thank you for joining us to learn about the City of Tacoma Rental Housing Code updates. This morning, we're going to learn about late fees and deposits, installment payments, notice of rent increase, and we are joined by our friends at Housing Justice Project, Lori Davenport, Wyatt Fisher, and then Jim Henderson, and Chapada Elder with City of Tacoma. And I'm going to go ahead and pass it over to our presenters.
Hello. So as Alexis just mentioned, my name is Wyatt Fisher. I'm a staff attorney at Tacomaprobono Housing Justice Project. We work closely with the Landlord Solutions, Tacoma Housing Authority, and the City of Tacoma to kind of make sure that everyone's on the same page about the updates to the Tacoma Rental Housing Code. So if we go to the next slide, today's presentation is going to be about money matters in particular. There's a number of things that were changed. But the main thing to kind of keep in mind is that this presentation is discussing the rental housing code as of July 24th, 2023. The City of Tacoma made some changes at a city council meeting about 2 weeks prior to that. So these only covered those changes. There are some, there's a ballot initiative that will be on the November 2023 ballot that may or may not amend parts of this, but this is what the rental housing code is as of July 24th. And this is not legal advice. So let's start with deposits and move-in fees. So it's a very just preliminary matter. The City of Tacoma implemented a new restriction on pet deposits so that a landlord may not charge a tenant more than 25% of 1 month's rent as a deposit for pets. That's very straightforward. It's a new rule. So make sure to keep that in mind. Additionally, the City of Tacoma added a new requirement that a landlord must place both security deposit and any last month's rent in a trust account. So before that had only applied to security deposits, and now also needs to be last month's rent. So those are two pretty straightforward things. This next section about installments for move-in costs is really particular in terms of what are the terms of the lease. So do pay attention as we go through this and reference TMC 1.95.040 to clarify if you have any questions as we go through this. So to start with, installment payments for move-in costs are not required in a certain circumstance as noted in that first bullet point. So where the total amount of the security deposit and any non-refundable move-in fees, and so just to keep that clear, that doesn't include the last month's rent if there is any, but if the total amount of the security deposit and non-refundable move-in fees doesn't exceed 25% of the full month's rent, and there is no last month's rent required at the inception, then a landlord is not required to offer installment payments. But if those two do not apply, any other case, a landlord is required to offer installment payments for move-in costs. Now, thing to keep in mind on the landlord side is that prior to these changes, tenants could request move-in costs to be paid in installments. Now a landlord is required to, at the time a prospective tenant applies to reside there, the landlord must provide the tenant the information about their right to pay these costs in installments. The City of Tacoma does have a form available through the landlord tenant information packet available to landlords and tenants. But you just want to make sure that you're providing that to your tenants when they're applying to move in.
That's just a reminder, and you just mentioned it, why it is that when in the application process, so you need to have information in your, you can put it in different places, but I would say that in your written criteria is a good place to put information that the resident does have the option of paying the move-in fees in installments. And then if you do approve that applicant or group of applicants to move in, then you would, at the time that they're doing the lease signing, you would also incorporate the installment form into that lease signing packet, so that again, if they would like to pay those costs and payments, then that form is there available for them to complete.
Thank you, Jim. That's a good point to bring up on the landlord side of things in particular. I'll note that next bullet point, that third bullet point under installment payments, that was an error on my part in putting this together, but just reiterates that it's security deposits, non-refundable move-in fees, and last month's rent are part of this scheme of installment payments being available. Now, another change that was implemented is that before the month periods that the timelines available for different types of leases have changed, essentially, depending on how long the lease is for. So for a 6-month or greater lease, a tenant may elect to pay in 6 consecutive and equal monthly installments beginning at the commencement of the tenancy. And so that's for all 3: security deposit, non-refundable move-in fees, and last month's rent. For 3 to 5 month leases, and this is one of the changes that was made that I don't believe was originally prior to these changes being made. This isn't one of the main ways that people could do move-in installments. So definitely update your processes if you haven't already for 3 to 5 month leases. But basically, a tenant may elect to pay in 3 consecutive and equal installments, monthly installments, beginning at the commencement of the tenancy. And then for month-to-month leases, so prior the RHC had anticipated month-to-month or 2-month leases. They withdrew the 2-month lease piece of things. So really 2-month leases aren't covered here. And there are very few circumstances where you're going to find a 2-month lease. Typically 2-month leases are going to just be essentially month-to-month leases. But a month-to-month lease, it's important to keep in mind that this is separate from the other 2, the 6-month lease or the 3 to 5 month leases, and that on month-to-month leases, we separate out security deposit and non-refundable move-in fees from last month's rent. So security deposit and non-refundable move-in fees can be paid in 2 consecutive and equal monthly payments, and then the last month's rent can be paid in 6 consecutive and equal monthly installments. And if for whatever reason that tenant doesn't stay for 6 months on that month-to-month lease, and they would still owe you that money back for the last month's rent, but it would just be pursued in the normal course of business outside of a tenant relationship if the tenancy is already terminated by that point.
Yeah, and for the housing providers out there, this isn't a new idea. I mean, we've had this in state law. We've had it in city law. Actually, the city passed it first. The state adopted what the city had passed about 5 years ago. So really the biggest change here is that we're giving more information at the front end of the tenancy about the option. And the second thing is the city has extended the number of months that a resident has to pay those costs in installments. So for most of you, you're going to be looking at that 6+ months kind of time frame and allowing them 6 consecutive payments to pay those move-in costs. And again, the form will help walk you through the schedule and when those payments. And so you want to absolutely make sure, 1, you need to put it in writing, and 2, that's what everybody can refer back to on what the expectation for the amounts and the due dates are.
And we'll have time for questions at the end if there are any questions about that. So rent increases. This was another big change that was made through the July 24th updates. Landlords previously were required to give 60 days prior written notice to increase rent. Now it's 120 days. And that's for any month-to-month rent amounts that would include parking, rent, and utilities if it's in the control of the landlord. I know most landlords are not charging a flat fee, but if for whatever reason you were to want to charge a flat fee, that would also count under that. And then that doesn't apply for subsidized tenancies and for deed restricted affordable housing. There are obviously rules separate to that. And then for a notice of rent increase to be valid and enforceable, there are specific requirements that landlords need to specify now. They need to specify the percentage of the rent increase and the amount of the new rent and then the date on which the rent becomes effective. This is essentially just to make sure that landlords and tenants are on the same page about when that new rent comes into effect. They need to serve the notice in accordance with RCW 5912.040, which should be pretty familiar to most landlords, that process. You also need to provide a landlord needs to provide a copy of the resource summary prepared for the city. That'll be available to you through the landlord resources available through the city. And then also, in order to have a valid rent increase, a landlord must comply with the city business license requirements. And that's relatively straightforward to comply with, but that would be a defense for a rent increase not being valid if you did not have the business license at the time that you submitted the rent increase. Late fees. So late fees, the City of Tacoma has limited late fees essentially to a maximum of $75 a month or 1.5% of the unpaid monthly rent, whichever is lower. So when you do the math, most tenancies are going to be the 1.5% amount. And just as an example, 1.5% of $1,000 rent would be $15. So you can kind of do the math there. If you multiplied that by 3, a $3,000 rent is going to be $45 as a max rent. Or if a tenant has 3 months of $1,000 rent overdue, then the max late fee total would be $45. Additionally, no other fees can be charged for the late payment of rent. You can't charge a tenant for a notice that they were late on payment. You can charge them the late fee, but you can't charge them to serve them a notice. Or any other attorney's fees or costs. Attorney's fees and costs are only available if ordered by a court generally. And then an additional protection that the city brought into effect, I think is going to be really helpful for tenants and landlords alike to kind of, again, remain on the same page, is that landlords are required to provide tenants with at least a quarterly written notice outlining the late fees that are due and how the tenant can how the tenant can come into compliance with paying the amounts due. And so this is, I think, on my side of things, I often see tenants who are shocked that a year later that they learn that they had some small amount of balance owing. And then because of that, late fees have been accruing for over a year. And so I think this will go a long way to helping tenants and landlords be on the same page and reduce any surprises, or at least make those surprises come less often. And then finally, no late fees can be assessed on any non-rent charges. And so again, rent includes monthly recurring charges. So if there's something like a one-time pest control fee and they didn't pay that, you cannot include a late fee for that.
I want to reinforce that the 1.5% is on the unpaid portion of their monthly rent. So if their rent's $1,000, they paid $500, you're only able to charge a late fee if, in fact, it would apply to the $500 balance in which they would owe it at the time that the late fee was assessed. And then also regarding the quarterly written notice, if you offer your residents the option of paying rent online through through a portal, then you can provide that written notification to your residents through like an email, and but you need to include information in that notification about how they can access their ledger online. Information related, to the late fee. That's the purpose of the ledger, so that again, the transparency, making sure that everybody's kind of seeing what the other person's seeing. Separately, if you don't offer your residents an online portal to pay rent, then you would do that in writing. You would send this to them. You mail them a copy of the statement with a copy of the ledger.
Thank you. Those clarifications. And then since this is about money, I also just kind of wanted to point out on the landlord side of things, if you were to violate some of what we've gone over, as well as some other things, there are civil penalties available through the city. And so it is in the best interest of landlords to comply with the requirements by the city. But this, for anyone watching, these are all under compliance enforcement for the Tacoma Municipal Code, and some of those are new from prior to the updates. And the last page is going to just say, for tenant side of things, if you do see that your landlord is not complying with some of these money issues, you can file a complaint with the City of Tacoma, and the City of Tacoma can kind of let the landlord know that, hey, you need to comply, otherwise you might be facing these monetary penalties. And I think that concludes our presentation.
Yeah, and then I would just encourage that if you do find that your landlord's not in compliance, or as a landlord, if you're not in compliance, take this as an opportunity to, the city is definitely the city's perspective. I'll let Jaquetta, speak more to this, but they want compliance. They're not trying to go out there and fine you for making a mistake, but they also want you to learn from the mistake and then do better next time. Of course, I think if you're a repeat offender, then that's going to change their enforcement and whether or not they, the penalties that they will charge. So I think, everybody should go into this as we're still learning it, because it only went into effect July 24th, just giving each side grace and positive intent of trying to get it right. And that's why we do these classes, so that everybody gets on the same page, so we can get it right.